Hello friends. We will take 10 more questions from our series and learn little bit more of polity. Also focus on the additional learning through the images on the screen. And that is Lady Justice. On the right, the traditional version of Roman goddess Justitia. And on the left hand side is the Lady Justice of India. And you can see the difference there. Justitia, her three defining attributes: the scales, the blindfold, and the sword. On the left is the redesigned Lady Justice of India, unveiled in 2024 by the Supreme Court of India, with her traditional Indian attire and no blindfold and no sword. Instead, she's aware of reality. And instead of the sword, there is the constitution, signifying her role more as a protector of the rights and not just an enforcer. Let's take the first question. The annual financial statement of the government presented before the parliament does not include the statements related to Contingency Fund of India, Public Account of India. See, hardly one fourth. Most budget related questions in our series, I find the performance has been poor. Reflect for yourself too and put efforts to build the required command in this area. Anyway, budget includes statements of all the funds and accounts of the Government of India, the consolidated fund, the contingency fund, and the public account, right? So when it says it does not include none of this, it includes all of these things. Next question. The Supreme Court of India has exclusive original jurisdiction in which of the following areas? Exclusive, that means only Supreme Court. Original means the petition in original application can be filed there. First statement says dispute between the government of India and a state. Now, this is absolutely correct. This is a provision very clearly given to us under Article 131 of the Constitution and should be a logical understanding for us, as who else will resolve such disputes anyway when they are between two states or between government and the state. Secondly, violation of the fundamental rights of a citizen. Violation of fundamental right is definitely an original jurisdiction, but it is not an exclusive jurisdiction of Supreme Court. While a person can directly approach Supreme Court under Article 32, they may also approach the High Court under Article 226. So it is original for sure, but it is not exclusive jurisdiction. So second is actually wrong. Third statement says dispute related to the election of Vice President of India. This is also correct. And this is a provision under the President and Vice President Elections Act of 1952. And the same goes for the disputes on the election of the president also. So the same kind of provision is there. So 1 and 3, these are the correct statements. Next question. How many of the following activities would not require a constitutional amendment bill under Article 368 of the Constitution of India? Now, first one says changes in the fourth schedule. Now, why would it not need? It will need a amendment. Yes, of course. If it is done as a consequential event of Article 2 or Article 3, then you would not need that. But as a general provision, if you want to change something, tomorrow you want to change Rajya Sabha allocation of seats, it will need a constitutional amendment bill. Then it says, second, amending the provisions of the fifth schedule and similarly amending the provisions of the sixth schedule. Now, these two actually do not need a constitutional amendment bill. So this is also specified in these respective schedules. If you're interested, you can read that. So the correct answer for this question is actually just these two because they don't need it. Let's see the fourth one. It says inclusion of a regulation under the ninth schedule. Of course, this will need a constitutional amendment bill under Article 368. So anyway, 2 and 3 are the only correct answer. Check your performance where it is. Then, how many of the following statements are correct with respect to the union territories in India which have a legislature? That is Delhi, Puducherry and Jammu and Kashmir. Some statements are given to us. Let us see. First statement, the legislature of the UT can make laws on any subject in the state list under the 7th schedule. Now, this is not correct. Only those subjects that have been conferred on the assembly of the UTs, for that they can make a law. For example, for Delhi, the assembly has not been conferred 3 subjects in the constitution itself. That is the item number 1, that is public order, in the state list, item number 2, that is police, and also item number 18, that is land. Similarly, Jammu and Kashmir Assembly, they have not been conferred the power to legislate only on the first two items of the state list. Puducherry can make, so basically this statement is wrong. They cannot make on any subject, only those subjects which are conferred to them. Secondly, it says the legislature of the UT can make laws on any subject in the concurrent list. That is correct. All the subjects are available to them and they are able to make laws there. Third statement says the parliament can make laws for the UTs on any subject of all the three lists under the seventh schedule. Now, this is also absolutely correct. Parliament retains its authority. Remember, the relationship of union territory with the union is very different from that of the states. States are independent entities, more like partners with separate areas of responsibilities. UT, as the name itself suggests, is union's territory, that is a territory under the union itself. And there is no separate existence like that of the states. So parliament can always make a law on the state list also. So for the UTs. Fourth statement says they don't have the forum of Home Ministers Advisory Committee, the HMAC, which is available for the UTs without the legislature. This is also correct. It is there, the HMAC is there only for the five union territories without the legislature. And logically so, as the UT Assembly and Council of Ministers in these three, they are always already there to manage the affairs. So HMAC is there for all the UTs except Delhi, Puducherry, and Jammu and Kashmir. If you want, you can read more on the Ministry of Home Affairs website on this matter. Next question is again some statements regarding the democratic institutions in India. First one says the Lok Sabha, constituted upon the dissolution of the previous Lok Sabha before the expiration of its duration, shall continue for a full term of 5 years. Now, this is correct. Any Lok Sabha, for example, a Lok Sabha election took place in 1996 before the expiration of its term. Expiration of the term would have been 2001, but much before that itself, in 1999, it was dissolved. So this newly elected Lok Sabha now will continue for a full term of 5 years until 2004. Yeah? That's actually happened as well. The State Legislative Assembly, constituted upon the dissolution of the previous assembly before the expiration of its duration, shall continue for a full term of 5 years. Very same as the first statement, like Lok Sabha, this is also correct. Same principle applies. Third says a panchayat, in a similar fashion, that is constituted upon the dissolution of the previous panchayat before the expiration of its duration, shall continue for a full term of 5 years. This is not correct. For panchayats, it does not work. Article 243E provides that such a panchayat shall continue only for the leftover term of the previous panchayat that was dissolved. Same applies to municipal bodies too. And this shall be logical for your understanding, because see, there are thousands of panchayats and municipalities in a state where having different timelines for the local bodies is administratively very cumbersome. So to have a synchronized election for all, it becomes necessary to have such a provision. An idea that is being talked about for union and state elections too, that is one nation, one election. It already exists, more like, within the state, all panchayats and municipalities have the election together. So anyway, 1 and 2 are the correct statements here. Next question. Which of the following statements is or are correct regarding lapse of bills in the parliaments of India and the UK? First says, in England, a bill lapses on the prorogation of the House of Commons. And in India, a bill does not lapse on the prorogation of the House of the People. Now, both are correct statements. In England, it lapses. In India, it does not lapse. This was a modification done under our system. In India, bills don't lapse at the end of each session, but only when the Lok Sabha is dissolved. Only then some of the bills lapse. And that is on the right, the broad organizational structure of Indian Army. Then 637 question. Article 107 is the issue here, where it says about the lapse upon the dissolution of Lok Sabha. The simple idea to always remember is that Lok Sabha is the only house that dissolves after a period of time. So any bill that has any string attached with the Lok Sabha, right? Any kind of string attached with the Lok Sabha will lapse when Lok Sabha is dissolved. Possibility when this will not happen is when there is no string attached with the Lok Sabha. That is, the bill is not even introduced in Lok Sabha, or the bill's control has reached in the hands of the president. In that case, also the bill will not lapse. So let's see the options. A bill pending for assent of president. So president has taken control. This will not lapse. A bill returned by the president for consideration. Again, it is under the control of the president. It will not lapse. Then a bill passed by the Lok Sabha and pending in the Rajya Sabha. So this will also lapse, right? This is the bill that will lapse. The other two bills will not lapse because this has got a string attached. Then, next question, which of the following statements are not correct regarding the contempt of court in India? So I'm sure you know that there's a Contempt of Court Act of 1971, and it defines various terms that we have used here: civil contempt, criminal contempt, right? So it says civil contempt takes place when a person acts in a way to lower the authority of a court. Criminal contempt takes place when a person willfully disobeys any judgment. Now, actually, these terms are just reversed. Let's see. So if you see this Contempt of Court Act, it defines civil contempt means willful disobedience to any judgment, etc. Criminal contempt means publication, etc., doing of any act whatsoever which scandalizes or tends to scandalize or lowers or tends to lower the authority of the court. So with that spirit, these are actually just reversed. Both are wrong. Third statement says, Supreme Court can punish for the contempt of any court or tribunal throughout the country. That seems also correct, and that is actually correct. So only the third statement is correct. 1 and 2 are wrong, so they are the answer because it is asking which is not correct. Then the next question, how many of the following statements are correct in the context of center-state relations in the Constitution of India? Look at the performance again. First statement says principle of federal supremacy is the guiding principle if any matter falls under an entry in the union list and also in the state list of the seventh schedule. What this statement is saying that if the same matter falls into both the lists, there will be federal supremacy. Now, this is not correct. Federal supremacy is not the guiding principle. It is harmonious construction, okay, which is the guiding principle. If harmonious construction is not possible, then only the federal supremacy will be imposed. Please read center state relations carefully on this. Second statement says a single state can invite the union to legislate on a matter given in the state list. Now, this is wrong. It has to be at least two states, okay? Two or more states have to do that, and that is Article 252. If you see that, so Article 252 very clearly says if resolution to that effect are passed by all the houses of the legislature of those states, so at least two states have to be there, then the act so passed shall also apply to such states and to any other state which adopts that by a resolution. So that's there. The third statement says a single state cannot entrust its executive functions to the union. This is correct. A single state can. So when it says a single state cannot, so the statement becomes wrong because a single state can do this. And that is relevant under Article 258A. That also I'll show you. 258A here very clearly says governor of a state may with the consent of the government of India entrust either conditionally or unconditionally to that government the functions in relations to any matter to which the executive power of the state extends. So earlier, 258 used to be there to make it more mutual. 258 was also added later. So all three are actually wrong. None of them is correct. Then the last question for this video. Which of the following statements is or are correct? First, every disturbance of public order does not necessarily constitute a breach of law and order. And every law and order violation is not necessarily a public order challenge. See, first statement is actually wrong. Second statement is a correct statement. Understand this. There's a lot of confusion, so I thought I'll bring some thoughts on this. An action may affect law and order, but not public order. The contravention of law always affects order. Okay? Any contravention of law will affect the order. But before it can be said to affect public order, it must affect the community or the public at large. And when the gravity of it increases to events causing national upheavals, such as revolution, civil strife, war, that affects the security of the state, right? So that becomes security of state then. I will make a bit more detailed video on this issue later. And in continue with the images in previous slides, if you focused regarding the command structure of our armed forces, this image here is the future of our armed forces command structure. That is the integrated theater command, ITC. That is what we are talking about. An ITC is a unified structure where assets from the army, navy, and the air force operate under a single commander for a specific geographical area. Read more about it. All the best.